Yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning, everyone. I am Andy Bennett. I'm the visiting judge for this session. I'm normally in Nashville, but I am honored to sit with Judges Stafford and Armstrong, and it's always fun to come here and visit everyone. We will hear the cases in the order in which they appear on the docket. Just so you realize it, I like to remind everyone that these are live streamed, so what you say you can't take back. Yeah, it's out there once you say it. So please remember that. For the appellants, when you come up and introduce yourself, let us know if you wish to reserve up to 5 minutes for rebuttal. And our first case will have participation from an interpreter, so it'll be a little bit unusual, but we'll make it work. And if there aren't any announcements, then let's hear the first case.
Abdoulaye, Mamadou versus Gatti, Kaltner, Bienvenu, and Montesi, PC.
How are you doing this morning?
Good morning.
My name is Abdoulaye Mamadou. I represented myself.
Would you speak into the microphone, please? So.
Yeah. My name is Abdoulaye Mamadou. I'm represented myself.
You may want to pull it up a little bit. There you go. There you go.
Yeah. And my police the court, and I want to keep 5 minutes.
Reserve 5 minutes for rebuttal.
Yeah.
Okay.
Yeah.
When you pray.
The reason why I'm here today, I have a case from Mississippi, but my lawyer was Gatti, Montesi, and when he got the case, he did a good job, but we take care of the case until when the court appeal in Mississippi said they remanded the case to the administration judge. On that day, when they say mandated to to the administration judge for all further proceeding, Reed Womble changed that to the Solomon. It was not Solomon in the first, it was mandated, it was ordered, but he changed that reward to the Solomon. And when he changed that to the Solomon, he never told me it was Solomon, and when I signed in that case, I did not sign in there for Solomon. And the case rewarded was mandated for the further proceeding, because I have a lot of problem for my neck, and I've been losing weight. Because at that time when they make it mandated, I was making like $12 an hour. And before that, I was making $19.55 an hour. Now I'm losing $7.55. When they mandated, they said for all further proceeding, the case was not closed that time. They mean any time I have not the lost wages, I can bring to the court. But when he have me signing that time, I didn't speak English. I have no idea what I signed in because I trust him. I signed him for that. I didn't speak English. I couldn't read. I depended on him. I couldn't read that time. Now, when I got a new job on June 2017, I bring the receipt, my check stub, I give it to him. I say, that's my check stub I'm making now. I was making, when they cut order, making like $12. And now I'm making $13.75. I still lose money. And I told him, I saw him the check because I wanted him to continue. I'm working on to making, because I was going to school. But he never told me the case was settled. He never told me that. I was continue to report him, and he never ever told me he ended the representation until September 1st, 2023. That's the day I ever heard him say, I did not represent you. It's in a page 10. It's in a page 10. And when I was reporting him, I was reporting because I'm suffering. Sometimes my check come only like $7. After they took all the deduction from the check, I'm only making like $7. That's what is left. And I come to him so many times. I told him, Reed, I'm suffering for the lost wages. Please help me, borrow something for me before the case done. But he never told me your case is closed. He never told me I'm not your lawyer. I never heard nothing about that until September 1st, 2023. Now, you can see, I think it was page 20, if I'm not mistaken, it was page 120, if I'm not mistaken, or 121, when I told him he was ignoring my call. The reason why I said it, I did not know all those years he's not represented me. I did not know he was having me signing for the Solomon. All I know, I'm gonna bring my check stub to him. He could tell me, as right now, before you go keep going, stop, because I'm not your lawyer, and B31 file. B31 was filed on April 4, 2019. April 4, 2019. What you mean, I have 1 year to report all of my lost wages. And he know I report those lost wages to him, but he never report them to the court. No one time. Second, I want to make it clear, this was not about the 252 weeks reward I was given. No, this was the lost wages I lost because it never proceeded by the court. It have never ever proceeded by the court. Second, when the Reed Wombal said, when I signed in the court, I say, I'm happy. I never said it. Anything he put over there, he's the one who wrote it. I only do is signing it. I only do is sign it because I only have is him. He's the only adjust. Yeah. When he said I was complaining from 2017 to 2018, I was not complaining about 252 weeks. I was complaining because I'm suffering. I need help. I come to him no one time. I go to a school, whatever I work like 6 hours, and go to school 3 hours, and go to work 6 hours. And in the time when I make money, my check come when they get everything, I only come like $7. That's all I was complaining. I was not complaining because the 252 weeks was not enough. No. The day I told him about the 252 weeks, it was because the check, insurance wrote that check 252 weeks, but the check is 197 weeks. It's 197 weeks. I just come to him, tell him, this check is not what they say. I did not complain about him at all. I did not. I complain about the check is not 252 weeks. Because if you say the check is 252 weeks, and then they pay me something before the 202 weeks, the check is going to be maybe like they pay me 300 weeks. It put me in a bad position. Whatever he was telling me, he changed everything. He changed everything. And again, when I say he's biased, it's clear he's biased. The reason why I say he's biased, Your Honor, because Reed Wombal, he know what he put over there, what he have me signing as a Solomon. When the appeal court say remanded and say for all further proceeding, he changed that to the Solomon. And his authority. He should not change. As a lawyer, he should not change what the court ordered them to do. He's biased in three things. One thing, because he knew what he put over there was false statement. He want to cover it up, that false statement. And again, this second one, he know, I couldn't speak English. I was vulnerable. I depended on him, and I trusted him. He took advantage of me. 31, he just, maybe forget about it, but I'm gonna come back to that one. Okay. And when the judge said, judge was Ariel, when he said, I invented killing. I did not invent any killing at all. This killing were here is the one from 2009, all the way down to today. My last day to the doctor was day before yesterday. I did not invent the killing. The judge put me in a bad position. Any evidence I have is going to be no valid because he said I invented not the killing. I did not invent not the killing. It's one killing because B31 to report the 252 weeks was filed on April 4, 2019. All of those dates, the judge said for the statute limitation, all those dates was wrong because the B31 gave me 1 year to until April 2020.
Okay. Your time is up. You'll have your rebuttal time.
Okay, thank you. Appreciate it.
Good morning, Your Honors. May it please the Court. My name is Matthew Byron of the Nashville Bar. I represent the Appellee in this case, Gatti, Kaltner, Bienvenu, and Montesi, or GKBM, or just simply Appellee. This is a legal malpractice case involving the Appellee's former representation of the appellant, Mr. Reed Womble, was of counsel at GKBM. He represented the appellant in a workers' compensation matter in Mississippi, starting in 2010. With all due respect to the appellant, although the appellee has never been able to completely understand the theory of malpractice in this case against the appellee, it appears to be based on the premise that Mr. Womble essentially failed to secure or attempt to secure additional lost wages on behalf of the appellant after the Workers' Compensation Commission essentially reopened the door following the affirmation of the award that he received. So essentially,
Counsel, let me ask you a question,
of course,
please. As I understood the appellant, part of his argument, if I understood it correctly, and obviously he can respond to this when he gets up in rebuttal, but part of what I understood him to say was that he did not understand the documents that he signed, that he could not read them and did not understand them. In reviewing the record, I'm not sure I've seen that argument before. Has that argument been made, or was it made to the trial court?
So, Your Honor, in response to that question, I would make 2 points to the court. Number one, any evidence that Mr. Mamadou made in the trial court with respect to any alleged statements that Mr. Womble made to him, any statements that he made to Mr. Womble, with respect to signing that settlement, respectfully was not made in any admissible form. In response to the motion for summary judgment that GKBM filed, Mr. Mamadou did not submit any declaration under penalty of perjury pursuant to Rule 72. He did not, although he did file a self-styled affidavit in response to the motion for summary judgment that GKBM filed, it wasn't sworn or attested to. So, yes, to answer your question, he did make conclusory allegations that he didn't understand it, but albeit it wasn't in any admissible form in the trial court. So hopefully that answers your question. But
Not admissible because he did not respond to the motion for summary judgment. Is that what you're saying?
correct, Your Honor. After GKBM filed its motion for summary judgment, which was supported by the declaration of Mr. Womble, stating that he had represented Mr. Womble throughout the workers' compensation proceeding, stating that under Mississippi workers' compensation law, he just simply is not entitled to the additional relief that Mr. Mamadou seeks in this matter, and that he did not fall below any applicable standard of care for Mississippi attorneys. Mr. Mamadou did file some sort of responsive pleading to that motion for summary judgment, but under Rule 56, with all due respect to Mr. Mamadou, he had to submit evidence in an admissible form to be able to rebut that. And so he did submit a pleading with general statements to make the allegations that he didn't understand what he was signing, but respectfully, it wasn't in any admissible form as he was required to do under Rule 56 of the Tennessee Rules of Civil Procedure. As I stated earlier, there was no declaration under penalty of perjury. There was no affidavit that was sworn to before Judge Ward had issued his order granting GKBM's motion for summary judgment. Mr. Mamadou did not file any motion for an extension of time to take discovery of GKBM under Rule 56.07. There was no affidavit filed to support that. So respectfully, any evidence or any statements that Mr. Mamadou is making in this oral argument in his apparent opposition to Judge Ward's order simply is just not in any admissible form as required under Rule 56. So Judge Ward also held that Mr. Mamadou's legal malpractice action was essentially severely time-barred under both Tennessee and Mississippi law. Now,
What you say essentially held. I don't see that in the order.
and that could be a bad use of words on my part, Your Honor. Judge Ward's order concentrated mostly on the failure of Mr. Mamadou to rebut the summary judgment filed by GKBM using expert proof, expert testimony from an attorney. But he held in a footnote that to the extent Mr. Mamadou attempts to essentially change his theory of the case, it would be time barred under both Tennessee and Mississippi statutes of limitation, regardless of which state's procedural law the court applies. And
Was the court required to determine which law applied?
we believe Tennessee law would apply because statutes of limitation are procedural, and this case was filed in the Circuit Court of Shelby County, but if the court happened to apply Mississippi law, which has a 3-year statute of limitations for malpractice actions, I don't think it would make any substantive difference. The reason for that, Your Honor, is because, again, we believe that any cause of action for malpractice, which GKBM vigorously disputes, but to the extent that, for argument's sake, any malpractice action did accrue, it would have accrued on December 1st, 2016, when Mr. Mamadou signed the authorization accepting the settlement of the workers' compensation funds, where he declared and he attested that he accepted the funds, he was completely satisfied with the representation of Mr. Womble, and that the representation of Mr. Womble had concluded. So although Mr. Mamadou makes arguments about he didn't completely know any specific legal rights that he may have had until Form B-31 was filed several years later, the constructive knowledge rule in Tennessee, I believe, would impute the accruing of any legal injury to Mr. Mamadou on December 1st, 2016. And with that being the case, he would have until December 1st, 2017 to file his legal malpractice complaint. And unfortunately, he did not file that until, I believe, August of 2023. So he is several years late. And if the court applied Mississippi statutes of limitation law, then he would still be time barred by several years.
When was the Mississippi case actually final?
Excuse me?
When was the Mississippi case actually final?
The workers' compensation case?
Yes, that's the only case in Mississippi, isn't it?
Sure. I just wanted to make sure you weren't trying to reference another case in my brief or something.
No, this case, the subject case.
I believe it was filed in
Final. When was it final?
2010. That's my understanding, Your Honor.
That's when the judgment became final?
The date that the workers' compensation case was filed to begin the proceedings, or the date that the commission...
When was the judgment final?
I'm sorry, I misunderstood you, Your Honor. The judgment was final in October of 2016 when the Workers' Compensation Commission granted Mr. Mamadou an adjudicature from the essentially the trial court judge in the workers' compensation case. So the commission entered its order in October of 2016, granted Mr. Mamadou an adjudicature, and gave him 252 weeks of lost wage benefits. And then 2 months later, Mr. Mamadou accepted those funds that he was awarded by the commission and signed the authorization in December 1st of 2016. Judge Ward also held in his order granting summary judgment that respectfully, Mr. Mamadou did not properly rebut the summary judgment that was filed by GKBM. And although, again, we believe that the substantive elements of the appellant's legal malpractice claim are governed by Mississippi law, even if the court applies Tennessee law, the result is still the same, as both states' laws are essentially identical. However, appellant was required, since this case was filed in Tennessee, appellant was still required under Tennessee Rule 56 to submit admissible evidence to rebut Appellee's motion for summary judgment. Appellee filed his motion for summary judgment supported by the declaration of Mr. Womble, in which he declared that he had represented the appellant. He described what he did in the case, which would represent him through the workers' compensation trial and through the affirmation on the appeal. He was familiar with the standard of care for workers' compensation attorneys in Mississippi, and that as a matter of Mississippi law, under workers' compensation code, appellant was just respectfully not entitled to those additional lost wages that he appears to seek in this malpractice claim. So therefore, appellant had to come forth with some sort of admissible evidence to create a genuine dispute of material fact. As I noted earlier, again, Mr. Mamadou filed some responsive pleadings to the motion for summary judgment, but again, they were not in any admissible form as required by Rule 56. So I don't think the court can consider his statements that he didn't understand what he was saying, or he didn't understand what he was reading, that Mr. Womble didn't explain to him thoroughly. And I think that's also, again, under Tennessee law, a party is presumed to know the knowledge of the contents of the contract that he signs. So without admissible evidence in the record to create that genuine dispute of fact as far as what Mr. Mamadou had knowledge of from Mr. Womble when signing that authorization. I don't think he has properly rebutted, from an evidentiary standpoint, the proof that Mr. Womble set forth in his declaration, that he explained it, that Mr. Womble signed the contract, and he accepted the settlement funds.
But aren't we applying Mississippi substantive law to this?
Yes, Your Honor. Mississippi substantive law, in our view, would apply to this, because this was a Mississippi workers' compensation matter, and it arose through the representation of a Mississippi counsel through that representation.
So why would we apply, as you quoted, Tennessee law on a person knowing the contents of the contract he signed?
Well, Mississippi law creates the same result. Mississippi also has a rule that a party is presumed to have knowledge of the contents of the contract that he signed. So Tennessee and Mississippi law are the same in that regard. Mississippi law also requires that in a legal malpractice action, a plaintiff has to come forth with expert proof to be able to substantiate their legal malpractice claims. So again, respectfully, Mr. Mamadou did not come forth with any affidavit or declaration or any sort of testimony from an expert to opine that Mr. Womble fell below the applicable standard of care for Mississippi attorneys in the field. And in the absence of clear and palpable negligence, which is really the only exception under Mississippi law for excusing expert proof in a malpractice claim against attorneys, he was required to do that. I would submit to the court and to the panel that the Mississippi workers' compensation involves a pretty complex issue of statutory formulas as it's applied to wages, as it's applied to just formulaic matters and decisions for how wage loss benefits are applied. So these are necessarily questions that Mr. Mamadou needed to have an attorney address against Mr. Womble to be able to properly rebut the motion for summary judgment that GKBM filed in this case. So in conclusion, Your Honors, respectfully, Mr. Mamadou's malpractice complaint is premised on a fundamental misunderstanding of Mississippi workers' compensation law. Mississippi workers' compensation law, it applies a statutory formula of wage loss benefits pursuant to the loss rating that is assigned to an injury. It is not simply the claimant gets the wages that he had before the injury and the difference of the wages that he had after the injury. The Mississippi Workers' Compensation Commission correctly applied that standard in its order, and as Judge Ward observed in his order granting summary judgment, the commission did just that. So we are respectfully asking this panel to affirm Judge Ward's order granting summary judgment to GKBM in this case. Thank you.
Thank you.
Okay, Your Honor, Mr. Womble himself, on page 77, he said, I don't speak English. I don't understand English, himself said it. This means he know when I was signing that I don't understand what I was signing, but I trust him. Second, when he said I don't have no affidavit, yes, I have affidavit. Volume 4 is in a volume 4. What they did when I went to the court, I went to court 4 months. I've been asking them to send the one is I already have affidavit. When he said I don't have affidavit, that was incorrect. I did have affidavit. And again, any settlement in Mississippi has to be proved by the commission, no Reed Womble. There is no evidence, no evidence. Mississippi Commission proved the settlement he was talking about. There is no evidence. It's clear, it's right here. It says any settlement have to be made 3 things. One, it have to be my best interest, the injury worker. It was not my best interest for him to collect, to say it's settlement. Second, I applied to the judge on page 93. The judge say the reason why he denied me because I don't file the B-31 on time. Why? Because he did not tell me the B-31 is filed. And again, I told him I was not complaining about the 252 weeks. I was not there. Is the lost wages, it never been reported to the commission. The commission never received it. And my medication, when I was asking him about my medication, even medication I have a problem, he did not take care of that until after he withdrawing. When I talked to the insurance, they told me, yes, we're gonna pay you. They pay me my medication. The medication, if the case was closed, they had everything. It was not closed. I still gone to the doctor. He did not tell you the truth. It was not true. And the case was not final. Because the remanded for all further proceedings, I only have two in this case. Benefits for the disability and medical. When the commission say for all further proceeding, they mean I still have opportunity. If there is lost, I can file. If he said the case was closed on November 11, 2016, it was not true. That's the day when the court said they remanded it. That's the day, a story that day. That's when the case remanded it to the further proceeding. It's not closed on that day. You cannot help but read one, but then because page 77, he said, I cannot. When I learned English, I was learning English when I was watching DCs. Somebody told me, Mamadou, come here. I just write in my language, come here. I learned the sound, I catch it. But I never been in a school. When we went to the court on August 21, I told the read Wambal, let the judge, I promise you, when I come back over here, I'm going to come back with the GED. I take serious. He cannot just validate all these false statements Reed Wambal made over here. The case was not closed, was not final. That's the day the remanded story. You know about the remanded because you do it all the time. When he says remanded, that's the day is continue. B-31, when it's a file, you have 1 year. When the B-31 file, you have 1 year to report any additional lost wages. And this B-31 filed on April 4, 2019. Now how he come up with the case was closed on October 11, 2016? It don't make sense. I'm not a lawyer, I don't speak English, well, but I'm trying to do the best I can. And I was working, I was taking care of 6 restaurants when I was over there. I got my leg, that's why I was taking care of my family, supporting my family. And when I come to him, I told him, I'm not able to take care of myself right now because I'm suffering for the lost wages. It's not because what he don't did nothing on that time. And be honest with you, there was no damage until April 4, 2020. There was no damage. There is no indication he did something wrong. Even making it clear, I even give him not the case. If I was not trusting him, I don't give him not the case.
Time is up.
Thank you.
Thank you very much.
I appreciate it. All right.
Thanks to both of you.
Can I get a 7 second? I just have like 4 cases I want to submit.
Give them to the clerk.
Okay. All right. Thank you.
Thank you. Going to wait just a second till we get some